Ladies and gentlemen in Bachelor Nation, we have breaking news to get to right now. Hello, it's Dave Neal, stand-up comic and host of Bachelor Nation News, coming to you with new information from the judge in the Clayton Echard v. Jane Doe court case rocking Bachelor Nation and beyond. Earlier today, we saw this filing in the minutes section of the Maricopa County court system. Response objection to petitioner's motion to compel lunch and for alternative relief. Now, this information we are still waiting on. We hear it's a very long file. In fact, I'm going to read from one of my amazing folks that's in the Maricopa County system. They're saying it's 71 pages for the response. And then the order signed by the judge for the motion to compel Jane Doe to get off her booty. No, that's not the words they used. That's the words that were texted to me. But either way, this is wild stuff, what I'm about to share with you. It involves Jane Doe's sister. It involves photographs that they are now compelling her through the court system to provide as proof that she had these miscarriages when she said she did, which of course would be a wild thing to accuse someone of not having. But the fact she hasn't provided any of this evidence is leading the judge to take matters into her own hands. I'm going to get into this right now. In the matter of Jane Doe v. Clayton Echard, assigned to Honorable Julie Mata, based on respondent's motion to compel, filed March 11th, and good cause appearing, it is hereby ordered granting respondent's motion to compel. It is hereby ordered compelling petitioner Janie Dodo Bird III to provide respondent with the following disclosures. Okay, let's go through this nice and slow here, the following disclosures. And again, my plan is to go live when we get a hold of that 74-page document, or excuse me, 71-page document. It's coming any moment now. Hit the subscribe button so that you are ready to go live. You can also join the Patreon for free. There's a free version of the Patreon, which is what I use to alert people that aren't on the paid version when these videos are coming. Patreon.com/Dave Neal. Join the free version. It's only going to ask for your email address. Okay? Or you can join the paid version if you want to help out. The earlier video from today is 100% demonetized. They demonetized it. I don't know why. I know. I understand. Some of these things are hard to talk about. All right. Here's what they are ordering Jane Doe to provide Clayton Echard with. Number one, all non-privileged records and communications related to the 2014 paternity matter involving petitioner and victim 0 in California. Now, this victim actually was outed. We say victim, but this man was outed by Jane Doe's attorney. We don't have much information other than finding out that through the deposition, Jane Doe was asked, was this guy, have you ever been pregnant before? And she claims, I guess under oath, I haven't listened to it, this is just what's coming out, claims under oath that she was pregnant with this other guy. Now, who is he? Well, he's not like necessarily famous, but he's clearly not wanting this information to come out. And people have said, well, Dave, if he doesn't want the information to come out, leave him alone. I understand that. But it is with massive privilege that he's able to, move on from his collateral damage or very specific damage from this case. And now 3 men since then, Mike Maricini, Greg Gillespie, Clayton Echard, and you could argue Woodnick, myself, and others have dealt with the wake and a no-wake zone, the collateral damage to all of this wreckage. No, so what is all non-privileged records? What does that mean? Apparently, the case isn't sealed, but the only people that can get this information are her and him, victim 0. So whether or not she actually provides that, I'm not too sure. Even though the judge is saying, hand it over. I want to know what's going on in that case. What do you have? The judge clearly sees a pattern here. I mean, why else would she care about a 2014 paternity matter involving petitioner and victim 0 in California? Well, she would care because she would see a pattern emerging. All medical records for petitioner from Planned Parenthood Mission Viejo from on or about July 7th, 2023. Now, she claims that she went anonymously to this Planned Parenthood. Others have called this Planned Parenthood and say, hey, they don't even do ultrasounds here, so she was just making the whole thing up. I'm not sure where the truth lies. She claims that the ultrasound that she says she doctored with Adobe Acrobat or whatever the hell she used, she claims that ultrasound was from Mission Viejo, and then she added the imaging lab from Scottsdale Medical Imaging Lab, SMIL. Smile, you're on camera. She added that afterwards. Now, she admitted to adding that. She admitted to doctoring medical records, which you should never do. You shouldn't do that because those records are there for reasons to prove, in the court and insurance purposes and all that. Like it's important why those records are not given out anonymously. You don't just go somewhere and they just print you off and fire you off an ultrasound. No. And you might be anonymous in the sense that I can't go into Mission Viejo and say, I'd like the records for Jane Doe. They'd be like, all right, go kick rocks, right? But it doesn't mean that she's anonymous. If she went to Mission Viejo, Planned Parenthood, they've got the info from it. The question is, how do you find something that doesn't exist? And that's what we're wondering here. Will she not share it because it doesn't exist? Or will she not share it because I don't know why she wouldn't share it? Or will she share it? And it does exist. In that instance, why hasn't she shared it before? Number 3, the name and contact information for the medical abortion pill provider who informed petitioner she was pregnant with male and female twins, and any and all communication between the provider regarding the same, including but not limiting to any sonograms and related records provided by petitioner. Oh boy. So Jane Doe claims that she received an abortion pill, right? And she never took it, but she received it. That was what she used to weaponize. Here's my abortion pill. Date me and I'll swallow it. Like I'm good at that. That type of and again, is this exactly what happened? I'm not too sure. Either they gave her the abortion pill, but then she says they told her it was male and female twins. So we know this didn't happen. I don't believe it. I don't know about you guys. I just don't believe it. That's my opinion, is that this didn't happen. There is no medical abortion pill provider she went to. And if she did, well, where's the information from that? And also, who is that person? Because it'd be nice to talk to them to say, did you ever see an ultrasound? And did you ever tell somebody, like, why would a medical abortion pill provider tell somebody the sex, the gender of their unborn baby fetuses that are 12 weeks old at this point? First of all, they wouldn't be able to tell from the ultrasound. And secondly, this just doesn't exist. And that's why I love why the judge is asking for it. Please, we'd love to see this. And if it does exist, guess what? I'll be on top of it to share this with you. Number 4, the name and contact information of the telehealth doctor petitioner spoke with on the day of the miscarriage and all communication with the provider regarding the same, including the images of the 2 stillbirth fetuses with the date clearly shown that petitioner alleges she provided. This is definitely not coming out. So Jane's attorney says they've got photos. They've got images of the stillbirths. And yet it was Jane's testimony that in November, she found out she must have miscarried in September or October. So she didn't even know. Interesting. She didn't know she miscarried. Why would she have photos of them? Although now she claims she sent those photos to her sister, who we'll get to in a second. But I think it's fair to say if you did miscarry, you would have contacted a telehealth provider, as she says, and I don't believe this is information we're going to see. It's crazy because we're watching justice play out in real time today. It's crazy. And by the way, I want to shout out to my team who went and made sure they were able to grab this publicly available document. Of course, as you guys know, the tea is hot for Dave's big boy right here. I want to thank our pal Chris for getting us the tea right here. I don't know which of these looks best. The hair looks pretty good on that one. So thank you for all of your work getting us the tea we so wish to share with all of you because it's the day of the big boy, okay? It's the day of the big boy. Number 4. So we got that, the images, compelled to share. And by the way, Jane's attorney has said, we don't feel like we need to share that. Well, now the judge has said share it. So do we listen to the judge? How does this work? I don't know. Number 5, the text messages between petitioner and Jane Doe the day of the miscarriage, where petitioner sent the image of the fetuses with all pertinent metadata. Pertinent metadata means not some screen grab from a 17 scanned, remember the scanned math papers you'd get in 3rd grade? It'd be like barely could see it, you'd on those scanning papers, they'd spit it out. No, metadata. Where's the original photos? You took this not that long ago. I got photos on my phone that are a few years old. Did you delete your phone? Phone got lost in the mail? What, like, dog ate the phone? Like, what happened, right? She said she has the text messages. They were sent to her sister. We redacted her sister's name right here. It is further ordered that petitioner must provide the above information no later than 5 p.m. on April 19th, 2024. Okay, so let's take a look at, what is that, next Friday? April 19th is next Friday. All right, 5 p.m., I guess that's West Coast time, Arizona time, on April 19th. It is further ordered. The request for attorney's fees and costs will be joined with previous requests to be heard at the trial evidentiary hearing on June 10th, 2024. Done in open court this 4th day of April, 2024. Wow. Signed by the Honorable Julie Mata. She's got a nice signature right there. Incredible stuff. Based on respondent's motion to compel, filed, good cause appearing, ordered, granting, and settling formal written order signed by the court on April 4th. Please note the court has signed a paper copy after the order has been scanned and docketed by the clerk of the court. You may obtain copies of this order, including certified, by visiting the clerk's office website. All parties representing themselves must keep the court updated with address changes, blah, blah, blah. There it is. And we wait for more. But there it is. Wild stuff. I do think we're going to have another video coming out. I do think we're going to have a live after this. I'm just waiting on that information to come in. It looks like it might be coming in any minute now. So hit the subscribe button, hit the alert bell, and get ready for that. Judge orders not just 2014 medical information, but text messages to sister. Judge making a lot of orders right here. She wants the truth, and she's ready to get down to business, and we're all here for it. We'll be back with more right after this.